Hi everyone, my name is Rachel Marks and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Stephen Marso, an Iowa construction lien law guru. Today's webinar's topic is Mechanics Liens. So without further ado, I'd like to introduce the fabulous Stephen Marso.
Thanks, Rachel. Hi, everyone. My name is Steve Marso, and I'm an attorney with Whitfield Eddy law firm in Des Moines, Iowa, and I'm going to talk today about Iowa mechanics liens. And I have some slides to share with you that I'll scroll through here. And Iowa mechanics liens is a large topic. I could give a presentation for hours on all the parts of it, but we have only 20 minutes, so I have selected a narrow scope of areas to address. Specifically, I'm going to talk about some of the lien requirements for residential projects versus commercial projects, because the lien statute treats them differently. And so if you're an attorney or a contractor, whoever doing liens, mechanics liens in Iowa, you need to know the differences. And so I'm going to talk about that subject, and I'm going to go to the first slide, which discusses Iowa Code section on definition. So the Iowa lien law is in Iowa Code Chapter 572. So it's a purely statutory lien, and so any rights, defenses, issues, etc., under the lien law are governed by the statute. So the first section of it defines some terms, and one of the terms it defines is residential construction. So the definition is on the slide here, and it encompasses what typically most people think of residential construction as single family or two-family dwellings. And there's some other terms there, but it also includes, at the end here, you'll see a reference to Chapter 499B of the Iowa Code. That deals with condominiums or apartments, and not all of them, but if they are designated as what's called a horizontal property regime, and that's what 499B addresses. And so those types of apartments and condos that are designated that way are deemed to be residential construction. So that's kind of the exception to what most people think of residences. Everything else other than residential construction is deemed non-residential or commercial. Those last terms are not separately defined, but essentially if you're not within that residential definition, then you are considered commercial, I guess, is what most people call it. Okay, so first, there are some common requirements that apply both to residential and commercial projects. So whichever one your project is, there's certain requirements you have to meet. One of them is the deadline to post a lien. Now, in Iowa, sometimes people hear or they think that the deadline to file a lien is 90 days from your last day of work, and that's technically not true, as this section shows. The deadline is 2 years and 90 days after the last date of work. So if you're beyond 90 days, all is not lost. The recommendation is to file your lien within 90 days if you can. And I'm not going to get into all the reasons why, but it has to deal with priority of your lien compared to other potential encumbrances on the property. So if you can, file your lien within 90 days, but if you're beyond, you can still file it as long as you're within 2 years and 90 days. Okay, so what happens if you're beyond 90 days? Well, technically, if you file within 90, you do not have to serve the lien on the owner, or the owner builder, I guess, if it's an owner builder situation. But if you're beyond 90 days, this is the statute that governs what happens. And it says here, as you can see, that the lien is only enforced to the extent of the balance due from the owner to the general, or if the owner builder, if it's an owner builder project, if there's someone buying it, whatever's due to the owner builder at the time the notice is served on the owner or the owner builder. Okay, so if you file your lien beyond 90 days and you don't serve the owner or the owner builder with that lien, then technically you haven't perfected it. And if the owner goes ahead and pays the general in full, while during that time period when you have not served the lien, then your lien becomes worthless essentially because there's no amount due. So what does this mean? The better practice is whenever you file a lien, serve it on the owner, even if you think you're within 90 days. That way, if it happens that you're beyond 90 days, you're still going to be, you still have perfected your lien. So that's kind of the takeaway for filing liens, is to typically always serve them. And what you can do, you can hire the sheriff or a process server or some third party to actually go personally serve a copy of the lien on the owner or the owner builder. Okay, so if you filed a lien, what's the deadline to file a lawsuit to foreclose it? The answer is 2 years and 90 days from the last day of work. So the deadline to file a lien and the deadline to file a lawsuit to foreclose the lien are the same, 2 years and 90 days. So 1 day before this deadline, you could technically file your lien, serve it on the owner, and file a lawsuit to foreclose. And you would be within technically the deadlines of all of those. Okay, so I mentioned earlier that there's differences between the requirements for commercial construction projects and residential. And I'm going to talk about a requirement that applies only to commercial or non-residential projects, and it's a notice provision. First off, it applies to people or companies furnishing work to a subcontractor. Okay, so these are lower tier subs. It does not apply to a subcontractor who has a contract directly with the general. Okay, so these are people like a supplier to a sub or a sub to a sub, those kind of lower tier entities. They have a notice requirement, and the notice has to be in writing. It has to go to the general contractor, and it's a one-time notice, and it's pretty simple. You can see that you have to have your name, mailing address, telephone number, and then the name of the sub to who you're furnishing labor materials for. Now, the big takeaway here is the deadline for this notice. It's 30 days from the first date of furnishing work. Okay, so it's an upfront notice. If you fail to give that upfront notice within 30 days of your first day of work, then you have no lien rights. Okay, so that's the important takeaway here. So if you're on a commercial project and you do not have a contract directly with a general, you need to give this upfront notice, and it goes to the general. Or I guess if it's an owner builder situation, you have to give it to the owner builder. Now, another thing you have to do is, if you're covered by this as a claimant, is when you file your lien, you have to put a statement in there. You have to certify under penalty of perjury that you gave the notice. So if you didn't give the notice, do not certify you did, because then you open yourself up to claims of fraud by making a false statement in the lien. So this is an important notice provision. If you're defending against a lien for a general contractor, for example, or an owner, and it's by a claimant who doesn't have a contract with the general, this is one of the first things you want to find out, is if they get the notice. Because if they didn't, you might have a pretty solid defense to the lien. Okay, so that's pretty much it for commercial. It's pretty easy. So there's not a whole lot of requirements on commercial projects. For residential projects, though, however, it's different. There's quite a few notice requirements, and the statute is created to protect the homeowner. Okay, so keep that in mind. And so the first notice is what I call a general contract notice to the owner. And right in the middle of the slide, you'll see the language that has to be given. And you'll notice it has to be in boldface type, a minimum size of 10 points, and you have to have that language in there. You can just copy it. And then on subsection 2 here, you'll see you also have to put the internet site address, toll-free phone number of the mechanics notice and lien registry. So if you get on the Iowa Secretary of State's website, that's where the registry is at. So everything that's filed with regard to a mechanics lien is through the Iowa Secretary of State's website. And so that's where you can find this internet site address and phone number. So the easiest way to do this is if you're a general contractor and you have a written contract or that you're going to have with an owner, put this notice language and the internet site address and phone number right in the written contract with your owner. So if you have a standard form you use, add this in, put it in there, and that way you've got it covered. Because at the end here of the slide, you can see if you don't provide the notice, then you have no lien rights as a general. So you have to put this in. Okay. Second notice requirement, and this applies to general contractors too, is a notice of commencement. Now, this is not something you put in a contract or just separately give to an owner. You have to go to the Secretary of State's website, and they have a form you fill out and file right on there. Okay, so here's the contents of it. But in the first paragraph there, you'll see in the middle the deadline for a general contractor or an owner builder who's going to contract with a sub. But your deadline is no later than 10 days after commencement of work on the property. So that's a short deadline. So if you are a general contractor who does a lot of residential projects, you need to know this deadline and just put it on your list, your checklist of things you have to do on every project is get this notice of commencement filed. Okay, it's 10 days from start of work. Now, if you're a subcontractor, technically there still has to be a notice of commencement. Typically, the general contractor is going to do it, or they lose their lien rights. But what happens if the general doesn't post the notice within the 10 days and you're a subcontractor? Well, you still have to post your notice of commencement. Okay, there has to be just one notice per project. Not for every sub, not for every general, just one notice for the whole project. If the general has not posted it, a subcontractor can. And you can go beyond the 10 days, okay? The subcontractor is not bound by that 10-day requirement. So as a subcontractor, that's one thing you want to check as well, is when you get on the project, has there been a notice of commencement filed by the general? If there is, great, you don't have to do anything. If there hasn't, then you need to file it right away. And then you'll notice here in the middle that the notice of commencement has to be sent to the owner's address, okay, by the general or sub. So, general, you want to make sure not just to post it, but you want to send it to the owner. If the owner's address is different than the project address, you need to send it to that other address where the owner is located. But if the project also has an actual address or post office, you have to send it there too. So you can find the details in the statute, but that's the main. So this is the main second requirement. Again, we have the initial general contractor notice. Now we have a notice of commencement. And if a general fails to do this one, they lose their lien rights, as I said. Okay. Last notice that we're going to talk about is a preliminary notice, and this is by a subcontractor only. Okay, not a general. So subcontractor, this is something you post to the Secretary of State's website on the lien registry. So they have a form, and you fill in the information, kind of like the notice of commencement. And then this has a provision that says your lien is only perfected, is only enforceable to the extent of the balance due at the time you post that notice. And then except for residential construction owned by an owner builder, it's only enforceable to the extent the owner actually receives the notice. Okay, so what's the takeaway from this? If you're a sub, you want to post your preliminary notice as soon as you get on the project. You know, you check to see if a notice of commencement's been filed. If it hasn't, you file it, and then you file your preliminary notice. And I would personally serve or mail those immediately to the owner, both at the project address, if it has an address, and any other address where the owner is located. And that way you kind of have your evidence to prove that the owner received this, okay? So we've gone over 3 notices: the general contractor notice, the notice of commencement, and the preliminary notice by the subcontractor. And these are all on residential projects only. Now I want to turn to a different topic and just make sure everybody knows that this exists. A lot of people don't realize this, but the lien statute has a prompt payment to subcontractor provision for residential projects only. Okay, this does not apply to commercial; it's only residential. And it says here that the general has to pay the sub in full within 30 days after the general has received payment from the owner. If the general fails to do that, then the sub can give a notice demanding payment, and if payment's not forthcoming, then the sub can sue. And if you're successful, it says here that the plaintiff, the subcontractor, can get an amount of not less than 1%, not more than 15% of the amount due. So if you're owed $100,000, you can get an extra $1,000 or $15,000 as kind of a penalty under this provision. So a lot of people don't realize this applies or exists. Now, a general can avoid that if it doesn't pay, the sub by the 2 items here, by showing one of those. If all the proceeds that you receive have been applied to the cost, so let's say the general's been paid by the owner and all of that money has been paid and applied to labor and material for that project, then the owner or the general avoids this penalty. So essentially, as long as you're using the money to pay for the project, you're going to be all right. If you're using it for other things, other projects or something else, then you're going to be in trouble. Or you can post a bond, as noted there. Okay, attorney fees. This is always a big topic because you typically have to have an attorney involved if you're going to be going after someone for a lien and file a lawsuit. So the first section of the lien statute that governs attorney fees says, as noted on this slide, and it said the thing to take away here is a prevailing plaintiff. Okay, so this is a one-way provision in favor of a claimant only. Okay, so if you're defending a lien claim as a general, for example, defending a sub's lien or an owner defending a lien, and you win, you cannot get attorney fees under the statute. But if you're a claimant, you can. So that's important. This applies to commercial projects, okay, and residential, so it applies to both. I noticed commercial projects up here because there's another provision we're going to talk to that applies only to residential, but this does apply to residential in the sense that if you're a claimant on a residential project and you succeed on your lien claim, you can get fees. The next attorney fee section applies only to residential projects. This allows someone challenging a lien to obtain attorney fees. So what this section and the previous section we just looked at read together, what this means is on commercial projects, only a claimant can get attorney fees. However, on residential projects, a claimant or the person defending against the lien can get attorney fees. Okay, so it's a two-way on residential projects. And at the end here, if the lien was filed in bad faith, you can get a little penalty in addition to fees. So anyway, so that's how attorney fees work in Iowa. And I believe we're at the end of 20 minutes, I believe. If anybody has any questions or.
Thank you so much, Stephen, for your time this afternoon, first of all, and educating us on, the different lien law requirements based off of, whether you have a residential or a commercial project. You provided us with super helpful information, and we appreciate that and your time today. So let's see if anyone has any questions. I don't see any in the question box right now. However, if you guys think of a question after the webinar, please feel free to reach out to myself or Stephen so that we can make sure that we answer any questions that you may have. And if you'll just go to the next slide for me, Stephen. Okay, if you guys would like to take a moment to review us on Google, we would appreciate that. If you go to the next slide. Okay, great. So the next two webinars coming up that we have with Stephen are on Wednesday, August 9th from 1 to 1:20 p.m. Eastern Standard Time, and that topic will be lien waivers and releases. And then the next webinar we have with Stephen will be on Wednesday, December 13th from 1 to 1:20 p.m. Eastern Standard Time. So go ahead and register at sunraynotice.com/education so that you guys will be able to attend these next two live webinars. And if you'll go to the next slide. And that's all I have. So if that's all you have, Stephen, I'd like to thank everyone today for their time. And I hope to see you on our next webinar.
Yep, I don't have anything further. So thanks, Rachel. Thanks, everybody.
Thanks, everyone. Have a great day.